Hello. I'm going to attempt to share my screen. Well, I did my presentation on forensic psychology, and I covered the areas of criminal competence, the insanity defense, psychological autopsies, and criminal profiling. For criminal competence, that's an issue that involves the competence to stand trial. And basically, you can't be oblivious to what's going on or confused about what's going on with your criminal proceedings to the extent where you just don't understand anything that's happening. So, competence to stand trial is a requirement that defendants must be able to understand legal proceedings against them and to help attorneys to prepare their defense. So, it basically means that they should be able to understand well enough what's going on that they can actually assist their attorneys. So, competence is distinct from the insanity defense in that it focuses on the defendant's present ability to proceed to adjudication and not past inquiries into criminal responsibility. So it's about, are they presently competent, not were they competent in the past when they committed the crime. So this is from article that I researched here about competence to stand trial. It says the minimum standards for competency to stand trial were set forth by the U.S. Supreme Court in Dusky versus United States. The U.S. Supreme Court asserted that CST requires that a defendant demonstrates a sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and a rational as well as factual understandings of the proceedings against him. In order to be considered CST, the defendant must possess certain fundamental cognitive abilities, including attention, executive functioning, memory, and language skills. So this brings up the like if the defendant has any neurocognitive disorders or anything like that, or an inability to express themselves through language or any kind of disability, they may not be competent to stand trial. Who is most likely to be judged incompetent to stand trial? Defendants who are most likely to be found incompetent to stand trial in one review, I think of 50 years of research, were unemployed, diagnosed with psychotic disorder, had a history of psychiatric hospitalization, and suffered from a severe mental disorder such as schizophrenia. So this brings us to the insanity defense. So some key things to understand about the insanity defense is that insanity is a legal term, not a psychiatric concept, and it is defined by legal standards that have evolved over time. So it's not going to be any definitions in the DSM-5 or anything. It's more like about morality and stuff. So it says most insanity laws place the burden on defendants to prove by clear and convincing evidence that at the time of their crimes they were suffering from a serious mental disease or defect and either lacked substantial capacity to appreciate the criminality or wrongfulness of their conduct or were unable to conform their behavior to the requirements of law. So, and then that brings us to not guilty by reason of insanity, which is a verdict that at the time of a crime, a defendant was suffering from a mental disorder and either did not realize the wrongfulness of the act or was unable to conform to the law. So that would be a verdict that you would receive if the insanity defense was upheld. So the insanity defense is meant to, I guess, be like a moral um, defense, and that if you can't understand what you've done or you can't conform to the law, then you're not culpable. And who is most likely to be found not guilty by reason of insanity? People with psychotic and affective disorders and previous psychiatric histories. Um, those factors significantly influenced forensic mental health professionals' opinion regarding whether they had a defect. So, yeah, they were thought to have a defect more if they had psychotic or mood disorders and or previous psychiatric histories. Um, Also, for some reason, racial minorities were more likely to be declared sane compared to their white counterparts, regardless of differences or similarities in their cases. Um, the defendants that were found to be not guilty by reason of insanity, most of them were volitionally and cognitively impaired in one study here, 89%. In general, individuals, wait, hold on one second, who exhibited psychiatric symptoms such as delusions, mania, lack of planning, hallucinations, and disorganizations were found to have labored under mental defect at the time of offense. So that's people who are actively symptomatic. A psychological autopsy is done to determine whether suicide, murder, or an accident was the most likely cause of death in certain cases that are um, ambiguous. They can be used to determine cause of death for legal reasons such as insurance liability, workers' compensation, wills, or to clarify whether a person died by suicide or homicide. There's no standard format for conducting psychological autopsies, though life records and interviews are often used. And there are questions as to validity of psychological autopsies because there are concerns about secondhand information, bias, and subjectivity. Um, Reviewing an article, there are questions as to what should the interview content be of a psychological autopsy. And in this article, it says that the psychological autopsy is a systematic method to understand the psychological and contextual circumstances preceding suicide. And the method usually requires interviews with one or more informants of the deceased. And according to Connor et al., interview content should include information about mental disorders, stressful life events, personality traits, medical illnesses and functional limitations, availability of lethal agents, medication, and key distal variables such as various aspects of family history, such as are there psychiatric disorders in the family history or suicide, and early traumatic life experiences. Criminal profiling is similar to psychological autopsy, but different. The main differences um, can be explained by the question, what did they do when who they are is known? So that would be psychological autopsy. And the second question is, who did it when what they did is known? That would be criminal profiling question. The main agency responsible for the research and development on criminal profiling is the FBI's Behavioral Analysis Unit. Concepts and approaches used by profilers have often not been objectively and systematically defined, so there's questions as to the scientific validity of it. And it's said that computerized prediction could perform at least as well as clinical predictions based that would be otherwise based on hunches and personal experience. Offender homology is related to the concept of criminal profiling, and it's kind of a complicated subject, but it's homology means the same. So offender homology presumes an inherent uniformity among offenders that is believed to underpin the analytic process incumbent to criminal profiling. So it basically means because the offenders are similar, they can be profiled as kind of like one thing. So there's then the homology assumption. The technique of criminal profiling involves an underlying reliance and thus assumption on there existing to some degree a commonality in the characteristics of some offenders and the behaviors they may commonly exhibit when perpetrating certain modes of behavior constituting a crime. It is this presumed dimension of commonality among some offenders which underpins the retroclassification process that is described as criminal profiling. So that's basically what I said, is that it's because they have something in common with their behaviors when committing a crime, when committing something labeled a crime. And it is because they have something in common that they can be profiled as, you know. So a number of studies have attempted to analyze various samples of offenders, but have apparently struggled to find evidence of the anticipated commonality among them and their behaviors that would be congruent with the proposition of the homology assumption thought to underpin the technique of criminal profiling. So there's the question of, are these offenders similar enough to be profiled together? And the argument is that there's no real evidence of that. However, so that would lead to the argument that maybe trade-based methodologies of criminal profiling may not be valid if these traits are based on the assumption that these criminals have something in common in order to be analyzed together as a group. And yet, research investigating the accuracy among profilers has rendered findings that appear to be incompatible with these propositions, meaning that there are accurate criminal profilers, which kind of flies in the face of the idea that there aren't similarities among these criminals. Various studies have demonstrated the abilities of profilers to proficiently identify the characteristics of unknown offenders. And here are the references I used. The textbook is in here somewhere, and 4 other articles. All right, thank you very much.